in Massachusetts whose student gets injured from what they consider some nonsense sport. You understand? But in West Virginia, you might have a case. That's why you have to know legally where are we? Where are we? All right. As a lawyer, you have to know where are we and what is the general thinking so that you can advise your client. OK, Massachusetts stated it holds that to hold releases unenforceable, to hold a waiver unenforceable in such a circumstance, they said pretty clear, would expose public schools, which offer many extracurricular sport opportunities, to financial costs and risks that could inevitably lead to reductions in those programs. Okay? So what I'm trying to show you is that this court actually said that if we let them sue for this, okay, every other school in this state that offers these types of programs, okay, would be exposed to financial risk and ruin because people would be suing them left, right, and center. Okay? So cheerleading is just nonsense in Massachusetts if you're injured doing it, but rugby is somehow important in West Virginia. Okay? As these examples show, courts vary, again, in their approach to releases and waivers depending on the particular facts in each case. The releases effect on other statutes and laws and the court's views of the benefits of the releases as a matter of public policy. So public policy is different in Massachusetts as it is in West Virginia as it relates to how they view certain waivers, and injuries. Now, all these cases, I will tell you, are fact specific. I'm not sure what the young lady got as an injury in the case of Sharon versus Newton. It may not have been that serious. It may be a different fact pattern if she was at the top of a cheerleading triangle or pyramid, and somehow whatever it was, some new technique that the coach was having them do ended up breaking her neck and paralyzing her for life, then it might be a different result. So I do say that to some extent, these cases may be fact specific, but for the most part, generally, if it's just an injury in Massachusetts, you're not going to get anywhere on it. In West Virginia, you might do better. And here, obviously, court ruled that the student and her father had ample time to read and understand the release before signing it. Further, that cheerleading activities were not deemed to be compelled and were not so essential to the public. So if she was injured, too bad. That's basically what they said. Next one. Is the agreement voluntary? Is the agreement voluntary? Well, courts have rejected arguments when they find that the participants do not enter into the agreement freely and voluntarily. Okay, so when you consider the following, the Whittington case. The Whittington case on page 1, second one from the bottom, all right? The Louisiana Court of Appeals upheld a jury verdict against the institute on the grounds that the release was not freely and voluntarily given, okay? A senior nursing student was required to sign the document, i.e. the release or the waiver, before participating in a field trip to a hospital. Now, you know this was a waiver because she had to sign this before any injury occurred. It's not a release, even though a lot of times these cases call it a release. They use the term back, interchangeably. Okay. So what happened here? On the way to the hospital, the driver, okay, of a 15-passenger van in which she was a passenger, okay, lost control of the van. The van turned over, and it ended up killing her, okay? So, what happened? She couldn't sue. Her estate, the people that represent her estate, is suing the school on her behalf. And the school, again, has to be defending themselves by saying she signed a waiver before she got on the bus, so she cannot sue us. All right, so let's look at this. Among the factors the court considered was the following. The institute did not offer an alternative class for students who chose not to participate in the field trip. 1, that the university required students to travel in a group and did not permit them to use their own cars. 2, and 3, that the university dictated the terms of the documents, okay? Students were required to sign the release of the waiver and release it from liability for a reasonably foreseeable danger, okay? So here's what I mean. This woman was killed, okay? She did not want to get in this rundown piece of crap 15-passenger bus to go on this field trip, okay? But the university told her a couple things. One, you have to get on the bus. Two, you can't use your own car. She must have said, okay, fine, I'll drive my own car. Two, you can't drive your own car, okay? And three, you have to sign this waiver before you get on the bus. So, in the question of, is the agreement voluntary? Of course it's not voluntary, okay? She had to do all of these things, otherwise she would not have been able to go on this field trip. And maybe she needed the field trip for this course, okay? So she was forced to go on this. And what they're saying is that students were required to sign and release the university from liability from what they considered a reasonably foreseeable danger. Meaning that when you jam all these students into a 15-passenger van, it is reasonably foreseeable that that van could get into an accident, okay? That's what they said. Now, of course, you have to believe that it would have been very difficult for the court to actually say, oh no, you signed the waiver, that's it, estate of this woman, whoever she is, and you don't win. Where she died, that is like crazy. Okay, so in this situation, the court's looking at who's in a position, who had all the power here in this circumstance. It certainly wasn't as the student who's just simply trying to graduate. All right, so the university was in a position to wield the axe here, and they did it. As a result, obviously the university lost, and the family was able to sue on behalf of the deceased daughter or relative. Who are the parties to the agreement? Who are the parties to the agreement? Very important. Many courts will invalidate a waiver or release on behalf of a minor, okay? This one's Scott versus Pacific West Mountain, okay? So you don't have a copy of this, but what happened in this case is that this young man was injured. He was injured at a resort, and I believe this young man was actually playing baseball. One of those scenarios where you do the baseball, and someone into like a net. Someone had swung the bat, okay, and ended up banging him in his head. He was seriously injured, and of course he signed. His parents were then got a lawyer and attempted to sue the resort. The resort again stands behind their waiver and said, no, you can't sue us. You signed a waiver, okay? And here's the distinction. Who are the parties to agreement? Okay, many courts would invalidate a waiver or release signed on behalf of a minor, okay? Here the court felt that the mother had signed away the minor's cause of action in the event he was injured. So the court, what they did here, because obviously this young man had a serious head injury from getting hit in the head with a bat. And whereas the court could easily have said, no, you signed the waiver, sorry, too bad, you lose, okay, like in Massachusetts, the court didn't say that. The court said the following: well, who signed this document? You know how these documents are said that will say, well, if you are under 18, if your child is, if you're under 18, please have a parent sign for you, or a guardian, all right? Well, in this case, this was a minor, okay? And the mother signed for him. He never signed, but he was injured, okay? Now, it could have been that the mother wanted him to get into the sport, whatever the sport this mountain resort was offering, wanted to do it, maybe more than the kid wanted to do it. But what the kid didn't have, he didn't have the opportunity, okay, to actually participate in this. His mother just signed him up for it, signed the waiver, and put him in the program, okay? What they're saying here is that this young man in this situation probably should have had someone other than his mother, okay, review this document, i.e. like a lawyer, review the document, and then with the young man, let him know, what it truly involves, and then if there's a decision to sign it, then it gets signed, okay? But the court said essentially that the mother signed away his cause of action, okay? In other words, he might have said, I wanted to sue. Maybe I wouldn't have signed that if I understood this, but you took that away from me by you signing it. So the question is, who are the parties to the agreement? You have to look at, who are the parties to the agreement that later are suing. Does the agreement contain ambiguous language? This is like pretty basic. Does it contain ambiguous language? Okay, releases and waivers will generally hold up in court if they use specific, clear, and unambiguous language, okay? Also, releases for a specific event are more likely to survive legal scrutiny than a release for a more long-term activity. Okay, so let's just go back to the specific, clear, and unambiguous language, okay? So this is just like what's going on with President Obama's, clear writing speech of 2010, okay? People want documents that non-legal people, non-lawyer people are signing to be clear. They want them to be bold and underlined, the things that are affecting them, the rights that they are signing away. If you have a waiver that is that clear, that is that well written, okay, a court will generally uphold it, okay? Will hold that, listen, you signed the waiver, you're not stupid, you understood it, it's clear, they wrote everything out for you, and what do you want me to tell you? You lose, okay? However, where they're unambiguous, where they're ambiguous, where they're not clear, they don't use specific language, that waiver can obviously be contested and may fail, in a court hearing. Okay. Also, releases for a specific event are more likely to survive legal scrutiny than a release for a more long-term activity. Okay. So what happens? It's right here at your university. You have a nice track out here. Other schools come to your university and use your track, okay, for whatever events that they have, okay? It probably makes sense for that university for your university, for St. John's, to do the following. Every time, to say it could be the same school, maybe it's, St. Francis Prep. Maybe they come here and use the track. Every time they come here and use it, your university, the courts would prefer, would have all those students from St. Francis Prep sign a waiver, okay? They're signing a waiver, they're running around the track, okay? If they get injured, it gets dealt with, however it gets dealt with, okay? But every time they come here, they're signing it, as opposed to in the beginning of the year, fall semester, September comes, they come here with a coach, and they come here with the students, and they sign one waiver, all the students sign a waiver, that waiver is good until the following May, okay? Now you have a situation where the groundskeeper that's supposed to keep, all of the, the glass and the nails and, whatever else could injure someone off of the track, maybe they're a little lax, maybe they're not working as hard, maybe they're not as concerned anymore because there's a waiver that's signed. You understand? Sometimes it causes people to just kind of lay back in the cut, all right? And when that happens, courts prefer that, you signed one, the kid signed one for the short term and not the long term. All right, so a long-term waiver might be held against someone who's engaging in the same activity over and over again. In other words, if St. Francis Prep comes here, every week, every month, let them fill one out every time, so that you guys, the university, knows there's a waiver signed. Check the locks, check the gates, check the grounds, make sure everything's safe. It keeps people on their toes, and that's why they're talking about that, okay? Uh-oh, this is wrong. Shouldn't be here. And I'm using this new system here at the courthouse, so I'm not going to come out of it to go back to what I want to go back to. It should come up. Okay. Okay, here's another thing. Some courts have rejected documents, releases, and waivers, basically that's what we're talking about, that do not explain the nature of the activity, including the difficulties, danger, location, and other details. If you go back to Learn to Surf LA, if nothing else, that waiver did explain all of those things. It went over all of those things completely, okay? Other courts require that the language that describes what is being waived be conspicuous, okay? Such as in bold and capital letters, so that it comes out at you, all right? Very important. Okay, what is the relative bargaining power? In other words, when someone comes in to sign a waiver for whomever, okay, what bargaining power do they have? What power do they have to say, well, I want to change this, I want to change that? Yeah. Do they have any bargaining power at all? That's a consideration. Okay. Courts may also take into account a number of facts, including the opportunity for two parties to negotiate. University of West Virginia, is that on here? Okay, you don't have this case, but here it is. In the case of the University of West Virginia, the court took into consideration the fact that the university's attorneys prepared the document, but that the student did not have the benefit of counsel. This is a situation where at this time, in this particular case, this young man was getting a scholarship to go to the University of Virginia, big deal, full scholarship, and he just shows up with himself, I believe with himself and just one parent. Okay, I don't know where the other parent was. And again, one side is him, just, I'm here. This is going to get me out of, get me to the money eventually, get me to the MBA. A person in that position, they're stoked. They'll sign anything that you put in front of them because this is their shot. Okay, so when that happens, when you have someone who wants something that badly, so eagerly. On the other side of the coin, you have the people who are controlling all the hands. They control everything, and that was the university, their lawyers. Okay, they prepared the documents. They went all over the documents. They may have just showed this person the last page to sign, and he or she never read it. Okay, so in the case of the University of West Virginia, the court took into consideration the fact that there was lopsided. There was no bargaining power on the side of the young man, who clearly, the reason there's a University of West Virginia case, okay, that means that eventually he got injured. He got injured and decided that he wants to sue the university. Again, the university says he signed a waiver. He should not be able to sue us. Okay, that's essentially what they said. And what happened? The court looked at it and said, well, when he signed it, who was present? It was just him. And who does the university have? You guys had 5 people on the other side, right? So he had no bargaining power. He had no position to actually, change any of the terms of this document or to renegotiate any of these terms. He simply was at the whim of whatever you wrote down. And to that extent, and because of that, we, the court, are going to invalidate that waiver, okay, because it's against public policy to have such a waiver under these circumstances, and we're going to allow the gentleman to go around the waiver and sue the university. That's what happened. Gross negligence and intentional acts. Courts will not permit institutions to waive their responsibility when they have exercised gross negligence, okay, or misconduct that is intentional or criminal in nature, okay? You cannot waive that. I tell you 100 times, doesn't matter what the document says, okay? If the institution, if the company, if the theme park, engages in gross negligence or misconduct, okay, that is not a waivable offense, okay, or circumstance. If they write it into their, into their things, i.e., we will not be responsible for, just say if this is swimming, for diving boards that have been broken and repaired. Okay, we're not responsible for any injuries sustained as to jumping off a diving board that we have sent out for repair. That's ridiculous. Okay, that's not negligence. That's gross negligence. All right. So you can't waive that. It's not waivable. It doesn't matter that even if it's written into the contract, you could easily sign it because no court would uphold it. That's what they're saying. Such an agreement would be deemed to be against public policy because it would encourage dangerous and illegal behavior. In other words, things that are against public policy, okay, all right, it's because if the government, okay, did not take a position regarding any of these items, then the people who are either providing the act, providing the venue, providing the service, providing the materials, they wouldn't care. They wouldn't care what they wouldn't care what they do. They would do whatever they do whatever they want to do with respect to how it is that they're managing their property and managing their service, because they would feel like they're not responsible. So public policy, i.e., government initiatives, okay, government initiatives are what puts in place, okay, through well, listen, let's just go back. The simplest example of a public policy initiative are seatbelts in cars. Okay, everybody knows from every single vehicle training and vehicle enterprise that if a car did not have seatbelts and you drive at X miles an hour and smash into something, you're going to get seriously injured or die. All right. So public policy requires, i.e. public policy being a government initiative, requires that all vehicles that are sold in the United States have seatbelts that are 3-point seatbelts, all right? They have to do that, right? A company could not get away with having you sign a waiver to say that we've decided not to put a seatbelt in this car and you're waiving any responsibility from any injuries that you may sustain as a result of that. That will never happen, okay? Because the public policy is that seatbelts have to be in cars, okay? Airbags have to be in cars, okay? All right? There's public policy all over the place. Public policy tells you, with respect to airplanes, the distance that people have to be, from each other in terms of the seat ahead of, the seat ahead of them and the seat ahead of them after that, because they've had enough testing to realize that in a crash, there needs to be a certain distance. These are all public policy initiatives and public policy designed programs. If a company tried to save money by writing out responsibility for that, they will still be held liable. And the final thing is ticket stubs and waivers. Ticket stubs and waivers. These things are often on the back of the ticket that you guys buy when you go to a sporting event. It's almost microscopic. They're very small. They're almost in like 0.01 font, okay? You can't even see it. But if you were able to enlarge it and read it, when you go to the Barclays, when you go to Coney Island, the tickets you buy, it's on the back of all those things. You are waiving your right to anything happening to you in terms of an injury. You're waiving the right to sue the Barclays, Coney Island for any injuries. It's on there. And you didn't even know it's on there. It's on there because you bought the ticket and you walked into the park, okay? And they presume that when you've done that, you are aware of everything that, that goes with, that's on that ticket, and the waivers, including the waivers, not just, how much to get on the Thunderbolt roller coaster, okay? So generally though, however, these tickets, these things are there, but generally this goes against waivered language being open, conspicuous, unambiguous, bold, and in large font. It goes against all of that. So it's very unlikely that any of those things, because you don't know that they're even there, would be upheld. Most fans never read them and never even know they exist. And that concludes well, let's see. Okay, that concludes my topic on waivers, and I believe that I'm probably going to send you I'm going to give you homework. I'm going to upload some fictitious waivers, probably 3 or 4, and I'm going to ask you for homework to design your own waiver using the ones that I've sent you as a guide. Right? You can use it as a guide and come up with your own. You can make yourself whatever kind of company it is, and you're writing a waiver that you're waiving your right to this, waiving your right to whatever. Just do whatever you want. You can use these as a guide to see what section should be in there and how it should be written. Okay? Don't rewrite. Don't fill in the blanks on the one I send you. type out a separate one and email it to me. You guys are going to be emailing stuff to me, all right? And also, I believe that by Sunday, I'm probably going to upload a quiz, probably be an essay format on waivers on this very thing that we just went over. So keep that in mind. All right, that's it. You guys take care of yourself and you guys be safe.